Hello, New Media Law class, and welcome to this lecture on digital music law. And in this class, we're going to look at a number of issues. I have a lot to cover, and we'll go through it kind of relatively rapidly. And the first piece that I want to look at is the background of technology, copyright, secondary liability, and fair use. And this is a theme that we've been talking about already throughout the semester, and it becomes particularly important, as you'll see, in the case law, which is pretty significant on digital music. To get into this question, we actually have to go back to a case I didn't ask you to read, but that I do want to talk about a little bit, which is the Sony case in the Supreme Court. And I mentioned this case in class last week. I have here on the screen a picture of the early Betamax machine. And as I mentioned in class, this was an analog tape recorder that you could hook up to your TV and record broadcast television. And at the time, a number of media companies actually brought a case to enjoin the sale of the device itself, saying that the device was facilitating infringement. Now, factually, there were some interesting pieces in the case. There was survey evidence done showing that most people who were using these devices were using them to time shift. In other words, they were at work and there was a show on that they wanted to watch, so they record the show and they can watch the show later. The surveys at that time did not show any decreased television viewing in general by owners of these devices. And in fact, there were some media companies that didn't even object, that didn't join in the case, and these in particular at the time were professional sports leagues who thought that it actually might be good if people could tape the game and watch it at another time. So the first piece of the case deals with this question of vicarious liability or contributory infringement. And of course, vicarious liability is a concept we're all familiar with. We're familiar with it from agency law, from tort law, and the court here notes that this is a kind of liability courts are familiar with. But here, the only connection between Sony and the user was the point of sale. Now, normally vicarious liability is that there's some degree of control, responsibility, supervision, like a principal and agent, employer, employee. But here, Sony is just selling a device. So it's difficult, the court said, to see how there can be some kind of vicarious liability if Sony is just selling a device. Another way to look at it is, does copyright law govern devices? And the court says there's really no precedent under copyright law or any kind of intellectual property law that just the sale of an article of commerce can be contributory infringement. Now, it's true, as the court recognized, that under patent law, there was and still is a doctrine that says if you sell a component that is put together in a finished product and the finished product with the component infringes a patent, the component could be, the seller of the component could be liable for contributory infringement if that component is not generally a staple article of commerce. In other words, if it's really specifically designed and the only real use for it is to combine it into something infringing, then there could be contributory infringement. But if it's just, say, a gasket that can be used in a whole bunch of different kinds of applications, a car engine, a plane engine, other things, and it just that particular gasket happens to be used in a device that, when put together, is infringing, the general sale of the gasket is not going to be contributory infringement. And that's the analogy that the majority in the Sony cases is drawing here. And so they're saying the sale of copying equipment, the sale of something like the Betamax, is just like the sale of any other article of commerce that does not in itself constitute a contributory infringement. And this is important language. The court says it has to be capable of substantial non-infringing uses. And the court did find, as we noted, that it was capable of substantial non-infringing uses. Now, why is it a non-infringing use for an individual user to time shift? I mean, aren't they making a copy? Well, this is where the Sony court gets into the question of fair use and says, is the direct use, the individual user, infringing, or is their use a fair use? And so we've talked a little bit about copyright fair use before. Copyright fair use is a fundamental component of copyright law. It is in the Copyright Act. It is not intended to be merely just a narrow exception to copyright law, but it's a fundamental part of copyright law. And there are four basic factors in a fair use analysis. What is the nature of the use itself? What is the nature of the underlying work? What is the amount and substantiality of the portion used? And what is the effect on the market? And so here the majority looks at this and says, well, what is the nature of the use? And under the law at the time, kind of the jurisprudence under fair use at the time of the Sony case, the courts tended to look at whether the use was adding something, was creating something new. Now, under current jurisprudence, we would use, we would talk about whether it's a transformative use. And whether or not now the use is commercial is still something we'll look at, but it was something that under the nature of use factor was probably more important under some of the older jurisprudence. In any event, here the court says the use is not a commercial use. It's broadcast television. You can watch it without charge anyway. So the fact that a user is recording it to watch at a later time is not a commercial use and is not presumptively invalid. Now, we might raise a question about this and say, well, what about the fact that it's possible to zip through the commercials? Now, we might... The heck? Now, test. Now, we might raise a question about this and say, well, I mean, isn't it possible to zip through the commercials? Aren't the commercials what support the market for broadcast television? And that might be a fair comment from our vantage point. We're used to digital. We're used to being able to do that fairly easily. It wasn't quite as easy to do that with the original Betamax. As to the effect on the market, the majority said whatever evidence there might be about harm from time shifting was merely speculative. There wasn't any real direct evidence that anybody was not watching television or that it was negatively affecting ratings in some way. Now, there's a dissenting opinion in this case, both on the question of fair use and on the question of contributory liability. So, on the question of fair use, as I mentioned, the purpose and character of use factor today, we would really mostly talk about whether the use was transformative. So, under the jurisprudence at this time, some of it would talk about whether the use was a productive use and whether it was doing something kind of socially beneficial. And the dissent says, well, it's not that kind of use. It's just an ordinary use for personal consumption. Now, this is going to be important or interesting in any event when we look at the Napster and the Grokster cases and how the Napster case treats fair use. The dissent says the majority ignores the nature of the work. This is a creative work. And this also is a really important piece, this discussion of the effect on the market, again, when we get to the Napster case, because the dissent says, well, maybe it's not hurting very much the existing market for broadcast television, but what is the potential market? What is the future market for broadcast television? And what is the future and potential market for recorded television? And the dissent is suggesting that the ownership of the copyright has at least a certain bandwidth, not only over the precise existing market, but also over potential future markets. That was not the majority's view, but the dissent took it up, and it gets taken up in the Napster case again. The dissent also says, the majority just really discounted the amount used factor because the entire work was copied. Then on the question of secondary liability, Justice Blackmun said, in dissent, said the question whether a significant portion of the use is non-infringing is really a question of fact. And this is an issue that ought to go to a jury, and in individual cases, a fact finder should examine it. Again, the majority in this case thought that they had enough ability to look at it without it having to go to a jury. Now, just a note, and I mentioned this in class last week, there are ways that Congress could get involved in this kind of issue and really sort of attempt to deal with it on the front end. And I mentioned the issue of digital audio tape. Here's a picture of a digital audio tape. You can see kind of the size of it, relatively small. And, as I noted, what happened with that technology is Congress said, well, we recognize that this can be used for somewhat larger scale infringement of music. It can be used for other things as well. It's unlikely to be found contributorily infringing under the Sony case, but what we're going to do is impose basically a tax on the sale of the equipment and allow that tax to be part of a compulsory copyright license. Now, interesting idea, and as I said, MP3 technology really displaced digital audio tape, really never took off in the market as a kind of consumer technology. So it does raise questions about, will this kind of solution actually get superseded by the market itself, even if you do try to adopt it? So now let's consider the Napster case, and we could say that the Napster case involves an early peer-to-peer network, and the legal analysis that I initially want to focus on is the analysis about fair use. But as we get into the case, let me talk for a moment about the kind of network that Napster represented. So let's consider first a typical client-server network. So you will have a computer that functions as a server, and you will have multiple client or peer computers. So let's say that this computer wants to communicate with this computer on a typical client-server model. It's not going to communicate directly, but that communication is going to go first to the server. The server is then going to route that communication to the other peer. You might have on many typical client-server networks, you might have some storage of files on the server. You might have the server connected to hard drives with storage. The local peers might have some storage. So, this computer wants a file off of this computer. Again, it will go through the server and get routed, and the file will get routed through the server. This computer might want a file that's in storage, and then this computer might be able to share that file as well. That's a more typical kind of client-server model. You might have multiple servers, and perhaps even multiple smaller parts of the network kind of network together. That's a typical model. So then let's look at a peer-to-peer network. And in a peer-to-peer network, a pure peer-to-peer network, all you would have is individual peer computers. You would have no centralized server. And these peers, if they want something from each other, or they want to talk to each other, connect directly to each other. This computer wants a file from this computer, there's a connection directly between them. Similarly here, and we can have direct connections between and among all of these computers. There is no centralized hub, no centralized server. Now, when we think about the Napster network, Napster was really a sort of a hybrid peer-to-peer system. You did have the individual peer computers, the individual users who want to find, say a copy of Springsteen's Born to Run. But there was a centralized Napster server. And so the first thing you would do, if you wanted to find that copy of Born to Run, was connect to the Napster server. Now, the Napster server didn't have music files, it had text files. And those text files contained information about other peers that are connected to the network and what music files they had available locally. So let's say this computer had Born to Run on it, an MP3 file. This computer wants it. It connects to the Napster server. The Napster server communicates back the text information saying, here's the IP address where you can get Born to Run, and then the connection is directly established and the MP3 file is transferred. So Napster server doesn't have the music file, but it does have information about the music file, and it is, at least according to some of the evidence in the case, capable of it is, at least according to some of the evidence in the case, capable of seeing what is in that text file and potentially even of blocking certain information from the text file. In other words, it has a certain degree of knowledge and a certain degree of control of what files are available for sharing between peers across the network. So the court in Napster, the Ninth Circuit in Napster, is going to look at the question of fair use. And on the purpose and character of the use factor, the court says downloading a file is not transformative. It is simply retransmitted in a different medium. Notice that the focus here isn't necessarily on whether it's commercial, but on what is actually done with the file itself, and nothing is really done. It's just in a different medium. Flippin' heck. So on the question of fair use, then the court looks at the purpose and character of the use factor and says there's nothing transformative. The file doesn't change, and further that the use is a commercial use. Now, note this citation to the Campbell case. This is an interesting citation. Campbell was a case involving Two Live Crew rappers who did a parody of the older rock song Pretty Woman. And the fact that the parody made money and was for a commercial purpose didn't necessarily cut against fair use, but it was a factor the court looked at. Now, with a parody, you're doing it for money. But the work is highly transformative because it's changing the underlying nature of the work. That wasn't the case here. Nothing changed, just commercial. As to the nature of the underlying work, it's a creative work. As to the portion used, the whole work was used. Then very interestingly, as to the effect on the market, and the effect on the market factor, as I was saying before, how this relates to the way the majority and the dissent in the Sony case were looking at the effect on the market. The Ninth Circuit here says Napster hurts the market in at least two ways. One is, and you have to put yourself back in the time that the Napster case was decided, where there was not yet a robust iTunes or other, $1 or $1.50 a song download market. Basically, you wanted a song, you had to buy the whole CD. And so the court said it hurts CD sales because people are downloading the songs they want or downloading all of the songs from the CD and not buying the CD. But also that there's a potential future market for the individual song downloads. Even though that market doesn't exist yet, the court said that's kind of within that scope of what the copyright holder ought to be able to control. And that's a bit different than the majority was saying. It's actually, I think, more consistent than with the dissent in Sony. So kind of an interesting move. All right, then on this question of secondary liability, the court says this is not like the Sony case. And this is where you have to tie in the way the Napster network functioned. So because that information resided on Napster's central server about who was having which songs accessible and which songs were accessible across its network, and because they had, at least according to some of the evidence, an ability to filter that, Napster then was considered to be encouraging and assisting the infringing conduct. And further, Napster had an ability to control and to supervise, at least to the extent that it had control over that text file. That then leads us to the Grokster case. And now here in the Grokster case, we're really dealing with a next generation kind of peer-to-peer network from the Napster network. So we'll take a moment now and look at the way the Grokster network functioned. So now let's consider Grokster. Now I think when you look at the music industry's litigation against peer-to-peer file sharing services, you'll see that the technology changes, and in certain respects the technology changes in order to sort of keep ahead of the lawsuits. I actually think the lawsuits in some ways pushed the technology. I think the technology was otherwise changing anyway, but some of it was the lawsuits. Some of it was the fact that broadband was becoming more available and more widely used, although not everybody had sort of the same ability to have a broadband connection. So under the Grokster system, you've got some peers that have more bandwidth, and those are designated as super nodes, and then others are just ordinary nodes. So the information about the files on the network is distributed across these super nodes. There is no one central location that contains either textual information or music files. And there's no central server controlled by Grokster that has that kind of information on it. So if this computer wants a copy of Born to Run, it may connect to this supernode. That supernode may tell it that it can connect to this computer and get that file if it wants it. So this is much more like a true peer-to-peer network, although there are these supernodes that are functioning somewhat like servers, but they aren't centralized servers. It's much more broadly distributed. So this is going to become important in the Grokster case, because in Napster, where you have that at least central place where there is information about the files kept, it's a bit easier to say that there's some kind of contributory copyright liability. In Grokster, you can't say that Grokster controls that technological capacity. And that's why the Grokster court really focuses on inducement and the advertising Grokster does in distributing the software platform that it does distribute. So then the Grokster case gets to the Supreme Court. We've looked at the nature of the network. Grokster also kind of aggressively advertises itself after the Napster network ultimately shut down, as a direct result of the litigation against Napster. Grokster advertises itself as we're the new Napster. You want what Napster had, you can come to us and get it, and advertise itself as being the place to go to download music. Grokster made no effort to filter any infringing material, whether it had any technological ability to do so or not. And its revenue model was really driven by advertising space on its site and through its software. So it made money the more connections there were. Now, the Ninth Circuit had said that contrary to the Napster case, Grokster could not be vicariously liable because Grokster did not monitor or control user activity and had no independent duty to police user conduct. It's just selling technology. and the majority of the Supreme Court disagreed. So Justice Souter wrote the opinion. Souter notes that there is either direct or inducing or vicarious liability. Now, the Ninth Circuit had focused heavily on, as you would expect, on the Sony decision. But Souter says, well, Sony doesn't say that any time a technology is capable of substantial lawful use, it's okay. Sony is really about the design of a product. Is the design of the product designed only for infringement? But beyond that, Souter says, there are other things that we can look at to decide whether there is contributory or secondary liability, and that includes whether there's an intent to induce infringement through advertising, not just through product design. And ultimately, Souter said there's clear evidence of that intent in this case. Indeed, he said that perhaps Grokster could have adopted some kind of filtering technology and could have certainly tailored its advertising in a different way, but didn't do so. Now, there are a number of other opinions in the case. We have an interesting contrast between Ginsburg and Breyer. You will actually often see in Supreme Court copyright law jurisprudence contrasting opinions between Ginsburg and Breyer. Often one or the other is in the majority and one or the other is in the dissent. But here, they both agree with the result, but Ginsburg says, look, the Grokster software is not even capable of a substantial non-infringing use. The only real use that it's used for is to infringe. Breyer wants to push back against that and say, no, actually there are quite a bit of possibility for non-infringing use. We don't want to get into regulating a technology. And indeed, Breyer thought that at the time that this kind of peer-to-peer software would become a bit of the wave of the future and was worried about copyright sort of closing that up. But he says here there is clear evidence of active inducement through the advertising, so that's all we have to get at. Now, interestingly, Breyer was sort of wrong about the technological future. I mean, peer-to-peer, I think it's fair to say, is still mostly used for sharing infringing copies of music and movies, and then also for pornography, including for contraband child pornography. And if you want to share files in a non-infringing way, for example, like I'm sharing edited copies of case law with you in this class, how do we do it? We use the cloud. So we'll use Google Drive or Dropbox or something like that, which is not peer-to-peer. It's, the file is stored on a server that Google or Dropbox or whomever controls. It's just that technology has grown, and there are fights in copyright and secondary liability dealing with those kinds of services as well. All right, so let's shift gears a little bit now, and that's kind of the background law about contributory and secondary liability for peer-to-peer type services. Of course, we also have the Digital Millennium Copyright Act, which deals with an internet or an online service provider that is hosting files. And that is where, to some extent, we get into some of these issues about the cloud. And of course, it is where we get into issues like YouTube and services like that. So what music-specific issues are there with respect to the DMCA and the red flag? Well, there's a really interesting case that I gave you to read, this Vimeo case in the Second Circuit. There are other cases in the Ninth Circuit, which I didn't give you to read just because we've already had a lot to read for this week, but we'll talk about the Ninth Circuit case law a bit when we meet together in class. So there is, even it's fair to say, a circuit split about some of these issues. And the Second Circuit takes a pretty strong, and some would say potentially extreme, position. So, the issue in the Vimeo case is, well, when does a service provider have red flag knowledge that there's infringing music on its site? And in particular here, you had a user video community, and some of those users were employing music as part of the soundtrack or background to the videos that they were creating. And you had some evidence in the case, some really, it would seem, difficult evidence for Vimeo that employees of Vimeo knew that there were recognizable songs that presumably were under copyright that were being used by their users as background music in some of their videos, and that they were essentially ignoring that or not paying very much attention to it. So you would think that this would be a case in which you've got some clear evidence that employees know that there is copyrighted music being employed as background in videos. There'd be red flag, but the Second Circuit says no. And it's a bit convoluted here because they recognize that the standard for red flag knowledge is a reasonable person standard. But they say this means a reasonable person who's not an expert in music or the law of copyright. And they seem to suggest here that that person could never really determine whether a song that is used is actually covered by copyright or whether the use is potentially a fair use or something else. And so effectively, some commentators think that this standard the Second Circuit adopts really guts red flag knowledge in music that is hosted on a site like this, at least if that music is employed in connection with video or in some other capacity. Now, like I said, the Ninth Circuit rule is a bit different. We'll talk about the Ninth Circuit rule when we meet together, but just be aware that this is another hot DMCA issue, and it affects our question about digital music copyright very directly. Another interesting piece of the Vimeo case is the question of the burden of proof. Now, if you think of course, the copyright owner in a normal copyright case has the burden of proving that there is infringement, that they own the copyright, and that there's infringement. The Second Circuit recognizes here that the safe harbor is potentially an affirmative defense, and so that if the infringement claim is brought, the provider has to raise and prove the affirmative defense. But according to the Second Circuit, the provider only needs to show that it meets the basic requirements for the safe harbor. It is an online service provider, it does have a notice and takedown, and so on. And if it shows that, then the burden shifts back to the copyright owner to show that the service provider, in fact, had red flag knowledge. The service provider does not need to prove the absence of red flag knowledge. Now, maybe that makes sense. Maybe that makes sense under the statute. Maybe it makes sense because it's hard to prove a negative. But it is, some in the industry, in the music industry, suggest that this is a real problem because it's, putting a burden back on the owner of the copyright that makes it much more difficult to prove, or at least to get, past summary judgment or an early stage of the case about the question of red flag knowledge. All right, now I want to shift to talking about the performance right and new media. So recall that music copyright is a bit peculiar, and we have to first of all separate out copyright in the music from copyright in the sound recording. Remember that copyright in the music would be, musical notation, a sequence, progression of notes, chords, melodies, harmonies, so on, along with any words. And, kind of typically, or at least historically, that would get published in sheet music. Nowadays, it's more likely to be, put into a PDF document or some other kind of file that you can download. But, if you're a musician, you get musical notation, the words, and so on. That is the music copyright. Now, if someone takes that and performs it and records the performance, in a digital recording or on tape or whatever, the recording is a sound recording, and that's a different copyright. The copyright in the music initially vests in the author of the music, the songwriter, author or authors of the music. The copyright in the sound recording initially vests in the author of the sound recording, which would probably be the producer. It may be a music engineer or others who contribute to that sound recording. So different kind of rights. So right now we're going to talk about music. We'll talk about sound recordings in the digital domain in a little bit. So now for the music, you have all of the rights of copyright, right of reproduction and distribution and performance and so on. The right to make a sound recording, to record a performance, make a sound recording for music is really governed by statute, and it's something called the mechanical license. So as the author of music, you have the first right to make the first recording. Once you have made a recording, anybody else can make a recording without asking your permission. They need to simply pay a statutory royalty, and those statutory royalties are administered. A lot of them are administered by a company called the Harry Fox Agency. So that is sort of covered by that statutory scheme. The right of performance, live performance, for example, is not covered by that statutory scheme, and absent some other arrangement, would need to be negotiated individually. Now, as you can imagine, it would be really difficult to negotiate individually with every cover band or whatever, or DJ, that wants to play your song at a wedding or a bar mitzvah or a party or whatever. Because of that difficulty in administration, these entities called performance rights organizations came to be. And what they are is private organizations that have publishers of music. It could be independent, songwriter, or more likely a music publishing company that is employing or contracting with the songwriter. And they, license their catalogs through these performing rights societies. And then the performing rights societies take on the responsibility of going out and kind of policing and making sure that people are paying the licenses they're supposed to pay. Now, how would they do that, right? I mean, even for a performing rights society to go out to every little wedding hall and so on is almost impossible. They do it. They do send investigators out. But the main way they do it is they have what's called a blanket license. So if you are a catering hall, or if you are a bar or a restaurant and you want to have music played, you would sign up with these societies and you would pay a fee per year based on, kind of which part of the catalog that they have available that you want, how big your venue is, and so on. And then you have audits and reporting that you do. So it's a blanket license. You get a lot of rights altogether. Now, if you think about it for a moment, what are these societies? They are potentially competing music publishers and songwriters agreeing on a license fee, on a price. And that ought to raise antitrust alarm bells. And indeed, historically it has. There has been antitrust litigation since at least the 1950s involving these performance rights societies, and that litigation has resulted in a series of consent decrees that are enforced by the federal courts. So the consent decrees kind of supply an interesting layer of law over this question of music performance that isn't directly in the statute, but that as a practical matter really governs pretty substantially how performance rights are administered in the United States. Now, a couple cases I gave you. This as I talked about all this, I've said, it goes back to the 50s and so on. And all of that ought to suggest that it's mostly pre-digital era stuff, and that's correct. So the digital era changes things. The music companies, the music publication companies, recognize that there's a different market here, and that their existing blanket licenses may or may not, probably not, in their view, be sufficient to cover the revenues that they think they're actually entitled to as a result of the market for digital. So two issues that have arisen. One is about downloads, and then the other is about streaming. So this first case, US v. ASCAP, is a case that involves downloads. So Real Networks and Yahoo are internet networks. You can see that the case is a little bit old, right? Because these are not the major ones we would think of today. And they do a couple things. They have some music that streams over their services, and there's a piece of this case that deals with royalty rate setting for streaming, which I cut out, and we're not going to really pay attention to that for our purpose here. They also had the ability to download music, and these weren't, I want you to know, these weren't illegal downloads, because as to the sound recording right, there's a negotiated license and royalty that covers that. The question is, for the songwriter or the holder of the copyright in the music, not the sound recording, can they also get a royalty through ASCAP, BMI, whatever, calling the digital download a performance? And in this case, the Second Circuit says no, a digital download is not a performance. It is simply a transfer of a digital copy, just like a photocopy of a physical copy would not be a performance. It involves the reproduction right. It doesn't involve the performance right. Now, of course, for the author of the sound recording, the fact that it involves the reproduction right matters. It's the sound recording that's being reproduced. The music, the sheet music, so to speak, is not being reproduced. So that effort for songwriters to get royalties out of downloads did not succeed. Now we have this other aspect which involves streaming. Now here you have Pandora Radio, which is one of these streaming services, and the Pandora is buying blanket licenses and is issuing those. Pandora is buying blanket licenses. So Pandora and other new media companies are buying blanket licenses, and they're claiming that the blanket license covers the right to perform the work digitally. And the members of ASCAP, some of these members of ASCAP who have their music licensed for performance through ASCAP, and again, remember this is the copyright in the music, not the copyright in the digital sound recording. So the holders of the copyright in the music have their performance license, and they're saying, well, this ASCAP rules and consent decree is really crafted originally for the analog age and really for live performance. It's not crafted for the digital age, and we should get more money for digital streaming. And so what they try to do is they say, all right, we're going to say that we will retain our songs, our copyrighted works with ASCAP for the purpose of traditional performance. We will withdraw our works from the ASCAP license pool for the purpose of digital performance. And then we'll negotiate individually for the digital rights. And the court here says, no, you can't do that. You can't do it because the consent decree, which is, remember, administered by a federal court, so therefore is a form of law. The consent decree says that the blanket license covers all uses. It doesn't carve out future uses like digital uses. And so therefore, for now, you're stuck with the rates that are approved in the consent decree for digital performance. Now, why not then say, okay, let's put pressure on, let's go back to ASCAP and let's say, ASCAP, you now tell your blanket licensees that if you want digital rights, you have to pay a higher fee. Now, ASCAP could do that, but that would raise another potential antitrust claim, and that would be subject to further scrutiny under antitrust law. And so it's pretty difficult to do that without, pardon the pun, opening Pandora's box. And there is, of course, lobbying effort and other kind of pressure to try and change that in the statute or in some other way. But I want you to note that this question of performance rights in music for digital streaming is a very live issue. Okay, the last piece that we'll talk about is digital performance rights in sound recordings. All right, now again, remember the music copyright is one thing, the sound recording copyright is another thing. So for music, there is a performance right. For sound recordings, traditionally, there is not a performance right. And this is part of the compromise. There was not a statutorily recognized copyright in sound recordings until 1972. And part of the compromise when that right was adopted, and that reflected kind of the growing importance of the recording industry, was to protect broadcast radio, analog broadcast radio, from having to pay additional licenses. So the compromise was you get a copyright in your sound recording to protect things like, tape recordings of your records, but that doesn't require the radio stations to pay an additional license. So the digital era comes around, and the record labels say, digital is different, right? It's a different dynamic. This isn't part of the compromise we made in 1972. And so here they do convince Congress to adopt a limited digital performance right in sound recordings. And I gave you the statutes and regulations to look at. You can just kind of skim through those. I think the most useful source one of the most useful sources for you to look at about this is the Sound Exchange website. And Sound Exchange is the entity that is authorized to administer this digital sound recording performance right. So, you can check out the site. If you go under the link for service providers, you can see that there are 3 different categories: commercial webcaster, non-commercial webcaster, or other kinds of services. So if you are representing a holder of copyright in sound recordings, or if you are representing a new media entity that is going to be streaming music, you'll want to get familiar with these different categories under the statute. I'm not going to ask you right now to kind of know the details. I just want you to know that there are these differences, and that the rates and the procedures for licensing will differ somewhat depending on what they are. You can actually see the rates. We can click here. So if you note, here the commercial webcaster. So note there's a minimum annual fee, which will depend on kind of the size of the entity. And then there is this monthly fee per performance. And that monthly fee per performance has been the subject of a lot of debate. There's been argument from some of the record labels that it's too low, that sites like Spotify are able to make a lot of money without paying enough royalty, and so there's a lot of discussion about where that rate will go or where it will not go. And you can also look here and see the kinds of reports. Again, if you're representing a service provider that is going to be streaming or otherwise performing digital sound recording, you want to get familiar with these reporting requirements so that you can help them properly to report the obligations that they have under the statute. So this is what I wanted to cover in the lecture for this week. So this is the end of the lecture, and we will pick up and look at some more of these details and talk about some more of these things when we meet together on Thursday.